Hi everyone, this is Carrie Cropley from SED 420, and I am doing my case review on is Parents versus the Lincolnville School Department Special Education Due Process Hearing on January 3rd, 2017. Basically, there was 5 issues at hand, and I actually picked this hearing because I just did a different class with Heather on exceptionalities in the classroom on ODD, oppositional defiant disorder, and that was one of the diagnoses that the student had, along with several others. The facts, in my own words, of this case are: got a young school-age student that is now his grandparents are his parents. They have adopted him because his mother was a drug addict addicted to opiates and couldn't take care of him. And he had a lot of trauma from the age of 0 to 2, which is quite common, I think, in that generation and in the past probably 20 years, actually, in the state of Maine, with grandparents and their children's children. He had been diagnosed with ADHD, ODD, dissociative disorder, conduct disorder, and he's got a bunch of different providers that had worked with him and saw him, from Eastern Maine Medical Center's psychiatrist to Child Development Services to Sweetster, day treatment programs, clinical psychiatrists, psych evals were done, OT evals were done, and any cognitive tests that were done showed that the student had some delays cognitively, but he wasn't too far behind to actually keep him out of the regular classroom, other than his behavior. He had, at a young age, previous school year, he had verbally threatened staff members, other students, thrown glass marbles at the face of teachers, and eloped from the classroom. And he also had done that from home in June, the end of June of 2016, which prompted all of what had happened in the next 3 months. He was put in the hospital for about 6 weeks, and he was regulated with medication that was changed several times. His daily intake of food was changed several times. They've tried the heavy blankets to help him sleep at night because he was having problems sleeping. He continued to have some sensory and fine motor skill delays that came out from the Children's Collaboration Center after they did their OT evaluation. There'd been several meetings in May of 2014 to see if he was ready for the public school system, which there was some conflict as to whether he was or not, but the district decided to allow him to come into the regular school setting. Up until that point, he had been in the regular school setting with, in your traditional classroom setting, not secluded in a one-on-one situation or a special education room. He did have a one-on-one and BHP workers working with him at home as well. He struggled at school for that 2014 to 2016 timeframe. So he had been at home with daily workers coming in after his release from the hospital in 2016. And then the parents or grandparents were notified that those services would be ending based on the fact that this child was violent and had actually eloped from the home and gone to a neighbor's house and broken bottles from the recycle bin and cut himself with those. So this mother called the school district that next day after she realized that in-home services had been terminated, and notified the district that the student would be placed back in school. So then in turn, the district held a informational meeting, as they put it. It wasn't titled an IEP, even though his IEP was coming due no later than September 17th of 2016. This informational meeting, as a district claims it was called, happened on August 24th. But there's no record of any written notice being sent home in regards to the meeting. No 10-day notice of the meeting was sent home to the grandparents, parents. But this informational meeting was held, and it was decided that the best placement for the student wouldn't be back in the district, it would be at the RSU's day treatment program. So the mother went and visited the program, and the next day signed the release papers so the student could start there. And the student started, and up until September 7th was going to this school, and had an outburst on that day and grabbed a pair of scissors that he found in the classroom and went after the teacher with those scissors. On this particular day, the teacher actually had called in sick, so the BHP worker was actually substituting as a teacher, and they didn't fill the void from the teacher not being here that day. So they were down one adult in the classroom. So after the student did that, the student took off, and other workers and staff in the school tried to stop the student, and he continually got away, went up to a second floor, ripped a sign off the wall, used that as a slide to go down the stairs. They called the mother to come pick up the student, and then she came shortly thereafter that. He had been at that point in time in a room with his worker for 45 minutes trying to calm him down. They had to use restraints 3 times during that 45-minute time frame to get the student to calm down so he wasn't a threat to himself or the workers. The building. The next day, the mother was notified that the student was suspended from the day treatment program. And after September 7th, that was the last day up until the parents filed this expedited due process hearing in October, the last time he was in any type of school setting at all. There was no meeting called by the district, even though his IEP had expired or was expiring September 17th. There was no meeting that was set up or held. The parents were just notified he was not allowed to attend school anymore. So there were 5 issues at hand that were brought up in this case. And the first one being, did the district violate the idea by changing or allowing the RSU to change the student's placement without first conducting the manifestation determination? Was the student's FAPE free and appropriate public education in the least restrictive environment from September 9th through the present? Was he denied that least restrictive environment as a result of a legal change in placement and inadequate interim educational services, which he should have had after he was suspended? Was the interim alternative education setting provided by the district on or about September 27th inadequate? And did the district fail to deliver interim alternative educational services? And did the district violate IDEA when it failed to return the student to placement from which he was removed once it was determined that the behaviors that led up to his removal were manifestations of his disability? So there were 5 issues in this case. The holdings in this case, actually, there were very few. The hearing officer ruled in the case that the student's right to a free and appropriate public education in the least restrictive setting was violated. The hearing officer also ruled that the student's maladaptive and unsafe behavior, there's a substantial likelihood of injury to himself or others, if he does not have a high level of support, currently only the private day treatment setting, the student's physical aggression towards others, as well as being unsafe with himself, requires that he be placed in an academic setting, at least temporarily, with the highest level of support. So at that point in time, the hearing officer ordered the district to place the student in a setting that would provide that, even though it was an hour away from their home, but it would give him the proper services, and he'd be back in getting the academics that he'd been missing out on for the past several months. And then that needed to be reevaluated within 45 days. The other piece of that ruling of the hearing was that the student's IEP did not take place in that time frame where it should have. So his right, or they did, the district did violate IDEA as well. I agree with that ruling of the hearing officer. That it seems like from what I read in the testimony, the school did try to find the proper employees to work with the student in a one-on-one setting, and to find the proper BHPs, but they could not. So that's how, after his release from the hospital, they decided to recommend the day treatment program that was part of the RSU. And the student's rights were violated by being suspended from the day treatment program and having no plan in place after that at all, just being told that the student was suspended, instead of coming up with an alternative education plan. It seems as though that the student had so many different tests done, and medications had been changed many times. It didn't seem like either it was the right placement or the right medications were in place or the right workers were working with the student at the time. He had quite an impressive list of professionals that had worked with him and evaluated him, and all the plans and recommendations that they had put in place had been tried and had been unsuccessful. There was one recommendation that when he was released from the hospital in August, that he be placed in a residential facility, and the grandparents or parents disagreed with that. That's when they called the district to say he'd be put back in, coming back into the regular school setting or the day treatment program. They suggested that after their visit. Really tough case to read, even though I'm sure it happens in Maine and on other states. I just don't want to label Maine that way. But the spiral effect or domino effect of the drug epidemic here has impacted our school-age children in a drastic way. Just behaviorally, the behavioral diagnoses that come out of being born dependent on whether it be opiates or benzodiazepines. It's quite enormous here, and it's hard and frustrating, I'm sure, as parents and grandparents and employees in the school system, not knowing how to best handle these situations and how to give these kids the tools that they need to be successful adults someday. Critical thinking question to the class. The one point that stands out to me in this was that the fact that this day treatment program that had supposedly all the right plans and policies in place to handle this student did not, and immediately decided to suspend him and not allow him back without even having a meeting or pulling in other providers or getting, opinions or coming up with a safety plan. Do you think that the day treatment program was in the wrong? Do you think that the school district was in the wrong? Do you think the grandparents were in the wrong? by not placing him in a residential setting as the hospital recommended when he was released in August? Do you think at some point, I mean, we all want to think our children are normal, but do you try? I think what I'm thinking after reading this case is the parents pushed and want him to be in a normal setting, thinking that's going to help him become normal, if there's such thing, instead of getting him the services that he really need? Or do you think that they did the right thing by not putting him in a residential facility and pushing him back into the regular school setting?